Now, back to our top story. Murder defendant Sarah Boone sending that brand new jaw-dropping letter to the judge. And it's important to remember that Sarah Boone is a repeat offender when it comes to running off attorneys and writing letters to the judge. She sent a 58-page letter after losing attorney number 8. A year ago, we watched her hand deliver a letter to Judge.
I'll have to talk to my JA about that. If you want to give me another copy, that's fine.
Yes, please. And do I normally get a copy? I haven't gotten one.
Well, it'll be filed in the case.
Please, if that would be okay, I would like to have that one uploaded. It's revised.
Having read the original letter, I did not believe there was any additional action that I needed to take.
Now, Boone is using this brand new epic letter to the court as a way of soliciting another zealous attorney with, she says, with a side of keen. Whatever that means. Let's try to make some sense of this, and let's talk about what His Honor should do with this defendant. I have a very special guest I want to welcome on the program this morning, Judge Elizabeth Shearer, who presided over the Parkland school shooting trial in Florida. She works now in the private sector as a civil lawyer. We're so pleased to have her. Good morning, Judge Elizabeth. How are you?
Good morning. How are you, Julie?
Good, thanks. Great to see you. So, Judge, I'm curious, if you were in this judge's position, tell us, please, what you would do with defendant Sarah Boone.
Well, here's the thing. First and foremost, people need to understand that you have a constitutional right to an attorney. You do not have a constitutional right to the attorney of your choice. So what I would have done, which is quite different than what this judge has done, not to say either one is right or wrong, but I would have selected an attorney off what we call the wheel of private counsel that have signed up to be court-appointed counsel for indigent clients once the public defender has a conflict and withdraws. And I would have chosen an attorney that I know has thick skin and can deal with clients like this. I would have had a pretrial hearing. I would have pulled the attorney aside with the state attorney, and I would have said, listen, this woman is very difficult, but I need somebody who can get this case through a trial. Are you up for the challenge? And that's the way that I would have handled it.
I like that idea, Judge. You know, where I practiced, there was a county office, they called it an office of conflict counsel, to take cases that perhaps the public defender's office was conflicted. I wondered if perhaps in your jurisdiction there was something similar, and those attorneys oftentimes had more time than to deal with cases like this one, right? And when you have someone who can maybe devote a little more time to somebody who can be kind of high maintenance, let's say, that can certainly be helpful. So with this letter to the court,
in this case,
yeah, go ahead, Judge.
I'm sorry, go ahead.
No, please, it's okay.
I think in this case, she's already been through conflict counsel. I think she's been through the public defender, then comes conflict counsel, then they go to the wheel, which is private attorneys who stand in as indigent attorneys or attorneys for the indigent once the conflict counsel withdraws. So I believe she's already been through both of those offices, and now we're private attorneys who agree to be basically special public defenders when needed.
I appreciate that, Judge. So now with this letter, it's a letter with that help wanted ad attached to it. It's going to the court. We're seeing it, of course, as you know, Judge, folks all over are seeing it because this case is huge in the world of true crime. People want to see justice for Jorge Torres. What, if anything, should the court do? Should there even be a response? Should the judge even dignify this most recent letter with a response?
I wouldn't. Absolutely not. I would just do a notice of filing, send it to the parties, and move on. I would ignore her. Obviously, she's trying to get attention. I think she's a bit of a narcissist, in my opinion.
I'm sure you are not alone with that opinion, Judge. We've heard a lot of people just outraged on social media saying the same thing. So when we get to the point of attorney number 8, and having to withdraw, and the court granting permission to withdraw, and then saying, enough is enough. Now it's time to represent yourself. Do you agree with that decision the judge made to cut it off at 8 attorneys?
See, I'm not sure that that's going to indeed.
Oh, and we're having a little bit of trouble with
Because
your
she
connection, Judge. Would you mind starting again? We missed the first part of what you said, please.
No problem. Can you hear me?
I can hear you now, yeah.
Okay. So I am not sure that decision by this judge is I don't think it's going to withstand appellate scrutiny because she has a right to be represented. So unless she has emphatically waived that right, knowingly, voluntarily, and intelligently waived her right to a lawyer and unequivocally asked to represent herself, the judge can't just make her do so. Even though her actions would appear that she doesn't want a lawyer because she can't get along with a lawyer. So what I would have done differently is I would not have let all of these lawyers withdraw. I would have given them a sort of a warning up front. And then I would have said, ma'am, you have a right to a lawyer, but you do not have a right to a lawyer of your choosing. I would put on the record that the lawyer is competent, the lawyer's tried many cases, the lawyer is very accomplished. All the things the lawyer's tried to do. You know, she's walking out of meetings with a lawyer. That's her problem. If she doesn't want to sit with counsel and she doesn't want to strategize about her case, that's her problem. That's not the lawyer's problem. The lawyer can only do what the lawyer can do and nothing more. If she doesn't want to cooperate, too bad for her. But I would not have let all of those lawyers withdraw. I would have told the defendant, you either cooperate or you don't. It's entirely up to you. But this is your lawyer, and you better get along with her, or you can choose to represent yourself. But that has to be her choice. That cannot be the judge's choice.
Love what you're saying there, Judge. Preach. Let's take a look together at some of what Sarah Boone is saying that she wants in an attorney. So we've highlighted some of the qualifications that must be included here. We've got open-minded, client inclusion at all times, a winning mindset, maintaining faith in the client. She goes on and on. Extraordinary expertise, original creativity. You know, I don't know what she's looking for here. Judge, do you think this is a game with Sarah Boone, or do you think she really and truly feels unsatisfied with those past 8 lawyers?
This reads like a want ad or an ad that you would put on a dating website. I mean, give me a break. Obviously does not want to go to trial. Obviously stops to delay her trial because she probably knows that her fate is inevitable. And this is ridiculous.
I couldn't agree with you more. It's ridiculous. I think it's pretty obnoxious. We'll see what happens, what the court does, if anything, on the next hearing date for Ms. Boone. Judge Elizabeth Scheer, great to talk with you this morning. We'll look forward to having you back very soon. Take care.
Nice to see you, Julie. Have a great day.
Thanks so much. And here's what's coming up next on Opening Statements.